Do you know the implications of the U.S. Constitution's Due Process Clause? Today, we will explore that and other elements of the Bill of Rights in this conversation between Professor Dr. Mark Tushnet and Dr. Abhinav Chandrachud.
Tushnet, it's lovely to see you again. I was just telling someone that I took your course on comparative constitutional law in spring 2009. And it's lovely to be speaking to you once again 10 years later.
Yes, nice to see you.
I thought that maybe we could start by, and I thought maybe I can ask you a few questions about the American Constitution, things that I would have loved to know when I was a law student, when I was an undergrad student, before I went to the US. So I thought maybe I can start by asking you, could you tell us about the US, could you give us a background about the environment in which the American Constitution was enacted? What were the times like? Why was the American Constitution enacted?
After the successful revolution ended with a treaty with Great Britain in 1783, the former colonies formed a loose confederation under what was called the Articles of Confederation. And that was a national government of sorts, but it didn't have a great deal of power. It couldn't regulate commerce among the states. It couldn't raise money on its own. It could only request contributions from the now states of the Confederation. And there was general dissatisfaction with the inability of the government under the Articles of Confederation to defend the nation, to promote economic development, and so on. And so starting really like 3 or 4 years after the Confederation was created, there was increasing agitation for amendments to that document, the Articles. There were a couple of efforts to amend them, but they failed. The amendment requirement was that every colony had, or every state rather, had to agree to an amendment, and there were a number of holdouts. And so in 1787, a final attempt was made to, formally speaking, amend the Articles of Confederation. A convention was convened in Philadelphia, and the people at the convention decided, rather than trying to amend what was a defective set of arrangements, they would create an entirely new constitution. And they wrote a new constitution with new powers for the national government. It could regulate the economy. It could raise taxes on its own directly from people in the nation. And they said it would go into effect when 9 states agreed rather than all 13. And there was, again, a sense that this was going to centralize power or increase power in the national government in a way that was likely to be more effective for the people of the country.
How did the American Constitution, when it was originally enacted, deal with the issue of slavery? And is it true that it saw a slave as only 3/5 of one person?
The framers of the Constitution were very aware of the moral concerns about slavery. Northerners tended to be anti-slavery. Southerners, where most slaves resided, were committed to the system, but were, again, aware of claims about immorality. The Constitution itself does 2 things. One actually is negative. It actually doesn't mention the word slaves at all. That was a conscious decision not to sort of advertise the existence of slavery. The other thing it does is contain a number of specific guarantees whose effect was to protect the institution of slavery where it existed. So there's a provision known as the Fugitive Slave Clause, although again it doesn't refer to slaves, that says when people held to service in one state flee to another, the other state has an obligation to send the fugitive slaves back to the original location. And the most important provision affecting slavery was what you've mentioned, something called the 3/5 clause. That clause deals with the allocation of seats in the National Congress and taxation secondarily. What it says is that seats in the National Congress are going to be allocated by population in each state. And the 3/5 clause says when you're counting the number of people in the state, you add up the free people, one for one, and then take 3/5 of the numbers of slaves and other Native American populations. And so you get one for one for the free whites, and then 3/5 for each slave. That was a compromise. Northerners or anti-slavery people didn't want slaves to be counted at all because any counting of slaves increased the representation for the South. Southerners slave owners wanted slaves counted one for one so that their political power would be increased by the number of slaves who, of course, couldn't vote. And so the compromise was at 3/5. It's in some ways misleading. Of course, it does say that a slave counts as 3/5 of a free person. But in the political context, it was in some ways a concession by the South and a victory for anti-slavery forces to say 3/5 rather than one.
What role did the Civil War have on the Constitution of the US?
Excuse me, I couldn't hear you.
How did the Civil War, the American Civil War, impact the American Constitution?
The Civil War was, of course, a traumatic event. Millions of people died and were displaced by it. And it was taken to, at least in retrospect, illustrate a failure of the original constitutional design. After the North won the Civil War, three significant amendments were adopted. They're in a period known as Reconstruction, and so they're known as the Reconstruction Amendments. I should preface this by saying the amendment formula in the United States is quite difficult. So there were the first 10 amendments, which were the Bill of Rights, done to satisfy a promise. And then there were two more afterwards that dealt with relatively technical issues. And then came the Civil War. That's a period of about 50 years where there's no amendment whatsoever. And then there are these three amendments. The 13th abolishes slavery. Slavery was the cause of the war, and it was fought ultimately to eliminate slavery, and the 13th Amendment abolishes slavery. The 14th Amendment is a complicated provision, partly designed to punish the South for rebelling by taking away representation. That never occurred. But more important, in the long run, the first section of the 14th Amendment guarantees rights against state governments. The Bill of Rights guaranteed rights only against the national government because, recall, it was created to alleviate concern that the national government would be too strong. There were no concerns then about state governments. And the 14th Amendment says we're now going to protect rights against state government. So due process, fairness in procedure, equality rights, and some substantive rights were protected by the 14th Amendment. And then a year later, the 15th Amendment is adopted, and that guarantees the right to vote without regard to race. And those amendments, in the long run, provided a transformed structure for the national government by, again, guaranteeing national supervision through the courts of the rights and rights violations by state governments.
So prior to the 14th Amendment, none of the actual amendments in the Bill of Rights were available against the state governments. So was it that the framers of the American Constitution weren't worried that the states would actually infringe citizens' rights?
When the initial Constitution was adopted, there was a sense that state governments were small enough to be politically controlled by the residents. And if a state government happened to violate or do something that many people thought violated rights, the thought was that the people of that government, of that state, would use political methods to eliminate the rights violation by essentially electing a new government. And so there was little concern at the time of the initial framing that you needed some national mechanism to protect state residents of states from rights violations by their state. Now, over the course of the next 60 years, the issue of slavery became framed as an issue of rights violations. And people came to see, anti-slavery people came to see states as major violators of rights, and therefore they did see a need to make the national government an additional protection for rights in the state.
What were the Jim Crow laws, and how is it that they were enacted despite the Reconstruction Amendments?
So after Reconstruction, the newly freed slaves were for a while full participants in the political process and were able to enact legislation on the state level and to secure their rights against state violations. But over the next 30 years, two things happened. First, whites in the South never really accepted their defeat in the Civil War and developed essentially a system of terrorism to keep the newly freed slaves from voting. For 10 years after the war, the national government used its military power to suppress this terrorist activity. But in 1876, there was something called the Compromise of 1876, which led to the withdrawal of national troops from the South and the revival of this kind of terroristic activity. The effect of that was to suppress black voting and allow whites to retake political power. Once they did that, they enacted laws now known as Jim Crow laws that separated whites and blacks in public facilities, a range of actions aimed at restoring or reinforcing a system of black subordination to the white population in an attempt to get back as close to slavery as they could get without reinstituting the formal legal system of slavery. And eventually the US Supreme Court endorsed these Jim Crow laws as reasonable regulations of essentially of race relations in the South.
What do you mean by the phrase judicial review?
So the U.S. Constitution doesn't specifically provide for what we now think of as judicial or constitutional review. What we define it as is the ability of the courts to find unconstitutional state or national legislation and to insist or to order that unconstitutional legislation not be implemented. There was a background history in the colonies of courts doing some modest degree of finding legislation of what we would now call finding legislation unconstitutional. In 1803, the Supreme Court said it's implicit in having a written constitution that the courts have the power to say the Constitution as the most important norm controls and overrides all subordinate norms, ordinary legislation that are inconsistent with it. That's not an inevitable conclusion, but it's one that settled into the U.S. system. And over the course of a couple of hundred years within the U.S. and now around the world, there's general agreement that a good constitution does provide for this kind of judicial or constitutional review.
Who was Chief Justice John Marshall? And can you tell us about the case of Marbury v. Madison?
John Marshall was the first important Chief Justice. He was actually the third Chief Justice, but he was the first Chief Justice of the United States who saw the job as a central feature of the U.S. constitutional system. He was a nationalist, a federalist, fairly strongly so, and he was on the court for more than 30 years, and a very powerful personality and a very powerful legal mind. So he dominated the court for his entire tenure, and his views became the court's views about the Constitution. The first really important decision of the Marshall Court was a case called Marbury and Madison. Madison was James Madison, who had drafted the Constitution and was, in the context of this case, the Secretary of State, which at the time was sort of the general manager of the government. It was a small government. There were only a handful of high officials, and the Secretary of State was, again, sort of the chief operating officer of the national government. The details of the case are complicated and are not that important. Congress had created some positions that were designed to be filled as a matter of political patronage. Then the party that created those positions lost the election, and the new party, headed by Thomas Jefferson, wanted to eliminate the positions. And there's this big conflict between the successors to the Federalists and the successors to the Anti-Federalists, which got to the Supreme Court in the case of Marbury and Madison. Madison, as Secretary of State, was really a stand-in for Thomas Jefferson, the president. And the case was resolved on the merits, or Jefferson won the case, but in the course of that, Marshall wrote an opinion establishing the power of the Supreme Court to strike down unconstitutional statutes. He did that in a way that prevented Jefferson from retaliating against the court. Marshall thought that it was more important to establish the principle of constitutional review than to engage in what was likely to be a losing battle with the new president. So the importance of the case is that it's the foundation of Marbury and Madison, is that it's the foundation of the U.S. principle of constitutional review, which again is not explicitly written into the U.S. Constitution as it is written into many constitutions today.
Could you tell us about the New Deal and the Lochner era?
So U.S. constitutional history can be divided into several periods. There's a period between the framing and the Civil War. There's the period between the Civil War and the end of the 19th century. And then there's a period from roughly 1895-96 to the early 1930s that's referred to as the Lochner era, that gets its name from a case, Lochner versus New York, in which the Supreme Court held unconstitutional a maximum hours law. At the sort of turn of the 20th century, there was a push for what we would now describe as social legislation, regulation of the economy, maximum hours laws, some minimum wage laws. And during the Lochner era, the Supreme Court actually upheld a great deal of this sort of social legislation, but it did so by using a doctrine or a set of doctrines that gave it the power to strike down social legislation that, in its view, went too far. And Lochner, the Baker's case, was a case that the court thought went too far. And during that period, the court saw itself and was seen by the public as the general supervisor of the of social and economic legislation in particular. Then came the Great Depression, the collapse of the economy at the end of the 1920s, the Depression, and the election of Franklin Roosevelt in 1932. That Roosevelt had a platform known as the New Deal, which included a great deal of social and economic legislation, again, aimed at recovering from the Depression. In the immediate aftermath of Roosevelt's election, the court actually seemed a bit sympathetic to these kinds of efforts to revive the economy. But in 1935 and 1936, in a series of decisions, the court invalidated central features of the New Deal. That provoked a very substantial political reaction. Roosevelt proposed adding a number of justices to the court. That failed, but the court got the message, basically, and changed its interpretations. And so the Lochner era ended. The court withdrew from supervision of social and economic legislation in 1937-38, and basically has remained removed from that domain ever since.
Could you tell us what the due process clause of the American Constitution is and explain concepts like substantive due process and procedural due process?
The U.S. Constitution contains two due process clauses, one in the Fifth Amendment and one in the 14th Amendment, and they both say that the government shall not deny due process of law. Initially, the term, there are two different kinds of due process of law, both of which have fairly strong historical roots. The most obvious one is what we call procedural due process. The term is due process of law. And the idea of procedural due process is that when laws are applied, they have to be applied through fair procedures. So procedural due process is just a way of referring to fairness in the process by which the law is applied. It has come to include things like representation by counsel at hearings, actually the requirement that hearings be held, that only relevant evidence be admitted, things like that. Things that you would think about if you have in mind a hearing before an agency about some social welfare benefit or a criminal trial or a civil case, the things you would think about in connection with the steps taken during those proceedings. That's procedural due process. The other domain is labeled substantive due process. Sometimes scholars in the United States make fun of the idea that there could be substance to process. But the term refers to a fairly long tradition that legislation itself, not just procedures, but legislation itself has to satisfy some requirements of fundamental fairness to people. It's got to be decent legislation or something like that. Much of the domain of fairness in legislation is covered by specific constitutional provisions. But substantive due process is a way of saying, even if you can't find a specific enumerated, listed right that this statute violates, it might be unconstitutional because it interferes with fundamental human rights not listed in the Constitution.
I think the American Constitution gave to American citizens the right to carry and bear arms.
The Second Amendment that protects the right to keep and bear arms has been very controversial in recent decades. The drafting, the amendment itself has a clause that refers to a well-regulated militia. And so for a long time, people thought that the right to keep and bear arms existed only in connection with service in a sort of state-organized military force. In the early 21st century, the Supreme Court held no, it protected an individual right to keep and bear arms. There's a decent amount of historical support for this individual right view. If you go back to the 1790s, when the Second Amendment was adopted, you see two kinds of things being said. You do see a little statement, a little fair number, but not an enormous number of statements saying we need to have a right to keep and bear arms to protect ourselves against, animals in the wilderness or attacking Native Americans trying to recover the land that we've taken from them. So there is some stuff about a right to bear arms as a matter of self-defense against what we would now call criminals. But in addition, there's a much stronger strain in the early period of people saying, look, we want this, the point of the Bill of Rights is to protect us against an overreaching government. And one way to protect against an overreaching government is to be armed if they, if the government in Albany, New York, tries to be oppressive. We can resist that oppression by coming out as an armed force. This got known as the insurrectionist defense of the Second Amendment. It's a pretty strong defense historically, but of course nobody wants to acknowledge that now.
Welcome back. In this final video, we looked at the Bill of Rights, due process, and judicial review. We hope these videos helped you learn more about the U.S. Constitution. You can also visit the American Center Library here at the U.S. Consulate General, Chennai to learn more. To watch other videos in this series, please click here.